Hi everyone. Thank you for joining and welcome to the inaugural Fire Starters event for asset recovery practitioners. My name is Jon Felce. I'm a litigator at PTB Litigation in London, and my practice focuses on fraud and asset recovery. I'm delighted to be chairing today's webinar on hot topics in the New World Order. But before I pass on to our esteemed group of speakers, a quick word about FIRE in today's format. As many of you will have gathered, FIRE is an exciting new global asset recovery community, bringing together key practitioners across contentious insolvency, fraud litigation, and international enforcement. Fire Starters, from which today's group of speakers derives, is targeted at the next generation of asset recovery practitioners, ranging from juniors to rising stars in the industry. We encourage everyone to get involved in the FIRE and Fire Starter communities, get your colleagues involved as well. As for today, we have a quickFIRE session of 7 speakers. They'll first let everyone know a new skill they've learned during the lockdown, turning to their topic. Sessions are short. We won't be taking questions from the audience until the Q&A at the end. We'll try to get as many questions answered as possible. Please fire in the questions you have in writing via the Q&A function available in Zoom. Raise your hand also if you'd like to be on screen when asking a question. You'll then be brought into the webinar and you can ask your question directly. Please let us also know, if you can, who your question is directed to. So that's the brief introduction for today. Without further ado, I will pass to the first speaker. But let me introduce him first. Our first speaker today is Sam Goodman from 20 Essex. Sam is a leading junior barrister in the fields of civil fraud and asset recovery. He has particular experience of heavy freezing injunctions, search orders, and injunctive relief. In the last few years, he's been instructed in numerous complex fraud claims, both in court and in arbitration. Sam was the youngest lawyer to be named in Global Data Review's 40 Under 40, which recognised his particular expertise in cyber fraud disputes. Sam will be talking today about recalcitrant defendants during the COVID outbreak. We'll pass over to you.
Thank you, John, and good afternoon, everybody. I'm delighted to be on the founding committee of Fire Starters and also to be speaking today at this virtual event. My new skill learned over the last few weeks is latte art, but it's fair to say I am very, very bad at it. One of the small joys of the lockdown is the tiny window you get when doing Zoom calls into people's homes. And with that in mind, I should apologise now for any four-legged intruders into the camera. I'm going to dive straight in because we've been given a quite strict time limit, and I'm going to be talking about recalcitrant defendants during the COVID-19 outbreak. And what I mean by that, of course, is defendants in particular to fraud claims who are using the coronavirus pandemic as an opportunity to frustrate litigation. And I'm going to cover the 5 Ds, which are delay, disclosure, debarring, delivery, and downright frustrating. And because of the time limit, I'm going to do so at quite a high level, but look forward to any questions afterwards. The first D then is delay. And I can deal with this one quite swiftly because there was a lot of guidance published about it by law firms and chambers in March when we entered the lockdown. Some parties, and particularly those that don't want to go to trial and don't want to fight applications, are arguing that their hearing should be adjourned as a result of coronavirus. The latest judgment on this issue is a decision called Municipio de Mariana and BHP Group. That's a decision of a few days ago of Mr. Justice Eyre, His Honour Judge Eyre. And it was an application in that case by the defendants to extend time to serve their reply evidence. But that was going to have the consequence of losing the June hearing date. And what the defendant said essentially was that international travel restrictions made visiting witnesses very difficult. And even with remote working, there were still very significant problems, such they needed a very long extension for their evidence. And in the course of his judgment, the judge referred, of course, to the new practice directions that exist on coronavirus. I won't repeat those. And considered 3 recent judgments of the court, the National Bank of Kazakhstan case in which Mr. Justice Tir declined to adjourn a trial, helpfully stating that the coronavirus pandemic necessitates the use of remote hearings wherever possible. Smith Technologies, which is another recent decision in which the judge dismissed the argument that there were difficulties with taking instructions remotely, And he even dismissed a party's claim to have a poor internet connection, and said, well, really what you should be doing is paying now to upgrade your connection. And a recent decision called Blackfriars, where John Kimball QC, sitting as a deputy, declined to adjourn a 5-week trial, on concluding that on the whole, remote hearings had been successful, and he directed the parties to work out how they should hold the trial. The judge then in Municipo concluded that on the special circumstances of that case, there were good reasons to extend the deadline for evidence, but he relisted the trial in July, so only 1 month later. And the clear message then is, unless there's compelling reasons, your hearings are going to go ahead remotely. An interesting point for present purposes is that in Blackfriars, there was a comment that that particular trial wasn't a fraud claim. And so it was the suggestion perhaps was that where you have a fraud claim, there may be a particular need to hold things like cross-examination in person. Certainly for my part, I can't see any good reason for that. I think that difficult cross-examination questions are just as difficult over webcam. My second D is disclosure. So your defendant has failed to comply with the disclosure order and they think they're off the hook because of COVID-19. What can you do about it? And there's 2 points you ought to consider. The first is, why ask your defendant to comply with their disclosure duties when you can get somebody else to do it for them? The very recent decision of Mr. Justice Foxton in Lakatamia Shipping and Nobu Sue, where the court considered lots of applications, but for present purposes, the relevant one was an application that required the defendant, Mr. Sue, to identify all of his social media accounts and email accounts and pass the passwords over to independent lawyers to review the documents and materials that were on them. It was obviously a very draconian order, and the purpose was to enforce a judgment and to police a worldwide freezing injunction. And the judgment itself contains an interesting decision of the various jurisdictional grounds to make such an order, but the conclusion was that the search order test ought to be applied, and on the facts of that case, that was fulfilled, and the judge granted the order, which had the effect, as I say, of taking disclosure almost completely out of the defendant's hands. And then the second point on disclosure is the court's power to strike out a statement of case. So another recent decision, strike it out when a party is in breach of their disclosure obligations. Another recent decision, which I'm sure many of you will heard of, the Byers and Samba Financial Group decision of Mr. Justice Fancourt, again only a few days ago, in which the court struck out parts of the defendant's defence because they had failed to comply with their disclosure obligations. And the court concluded that as a result of that, it was impossible to hold a fair trial on certain issues. It did allow a trial to go ahead on a number of limited issues where a trial was still possible, even in the absence of disclosure. But the court gave a clear warning in its judgment, and it said that this would put off other litigants from abusing their disclosure obligations. My third D is debarring. That's relevant where, for example, the defendant has simply failed to pay an interim cost order, and they hope that he or she hopes that they will get away with it during the coronavirus pandemic because it will be difficult to enforce. And I have some personal experience of that. I'm acting at the moment in the Tom State Group and Wojciechowski litigation. Only yesterday, Mr. Justice Zaccaroli handed down a judgment following a Skype hearing we had last week, in which he made a debarring order against the defendant, which required him to pay an interim cost order of about 70k, all face being debarred from a big chunk of the proceedings worth many millions of pounds. And the background was that the court made this cost order in early March and the defendant didn't pay. They said they couldn't pay, but they didn't give the full and frank disclosure of their asset position that they were required to give to make good that submission. And as a result, the court made the debarring order. Conscious of the time, I take my final 2 Ds very quickly. The fourth is delivery. I don't really mean delivery here, I mean service. I just couldn't think of a way to shoehorn that into a D word better than delivery. So service. And there's not a lot to say here. There's recent reports of alternative service orders via Facebook and WhatsApp, etc. But all of that has been pretty routine now for several years. What perhaps is interesting is personal service in committal applications. So I'm preparing a committal application at the moment, and we will need to apply for dispensation of the requirement to personally serve the relevant injunction and the application itself, because the defendants are all resident in Eastern China. They were all resident there in March when the order was made, and it's almost impossible, if not impossible, to serve them personally. And I fully expect the court to be very sympathetic to that argument, but it does mean that things like read receipts on emails and delivery notifications are extremely important. And my final D is downright frustrating, and that is some of the technology in remote hearing. So I should say the manner, in my experience, in which the court, the staff and the judges have dealt with remote hearings has been extremely impressive, and the judges have been extremely patient. But 2 short points before I leave you. First of all, time estimates, everything takes much longer, and so issues can get spread across several hearings when you want them to be dealt with in one. And secondly, the technology. Skype for Business I found to be pretty bad. Unfortunately, telephone hearings are very difficult. The best option, I think, is Microsoft Teams. The courts won't use Zoom because of GDPR concerns. Those are my 5 Ds. I hope that's interesting, and delighted to answer any questions you might have at the end.
Great. Thanks very much, Sam. Now on to our second speaker, Joana Rego from Raiders. Joana is a co-founder of Raiders. Is a Band 1 investigations firm specializing in disputes. Joana herself, she specializes in complex and high-value asset recovery, acting on behalf of multinational corporations, third-party funders, insolvency practitioners and financial institutions, as well as sovereigns and high net worths. In addition, Joana's practice is also anchored on providing investigative support in complex litigation and arbitration, fraud and corruption in investigations. Joana is fluent in 5 languages, and she'll be speaking today about asset recovery in a time of crisis, the good, the bad, and the unpredictable. Over to you.
Thank you so much, John. And thanks also to Thought Leaders for having me on today. I'm really delighted to be part of this founding committee. As for my skill over the past 6 weeks, in addition to very slowly perfecting my primary school teaching skills, which I am really looking forward to delegating quite soon, I have started making my own bread. I'm not getting too excited about it, but it's not a proven skill, but it's definitely getting better by the week. Now onto the topic. Irrespective of COVID, asset recovery and unpredictability, they do go hand in hand. And in the very short 5 minutes I have, I thought of cramming some ideas into these 3 buckets: the good, the bad, and the unpredictable. So first, the good. We're talking about a world that is now significantly poorer. We have an economic crisis that has brought about a real desperate need for liquidity. We open the newspaper and we see that the world is really now filled with cash-strapped millionaires and billionaires. So what this means is, the sudden need to access liquidity will automatically mean sort of a degree of movement of assets. And hidden assets, they're secure only while they're hidden. The current crisis, or really any economic crisis for that matter, it creates a situation where pots of money have to be accessed. And assets have to be sold, they have to be transferred, they have to be unwound, they have to be restructured. And this is a fact for those that are openly quite rich, but also for those that are concealing assets. So what does this mean from our perspective? Firstly, because turmoil creates movement, this means that now is precisely the time to be monitoring the movement of assets around certain individuals, around their known positions, as well as their front men and women. Secondly, because this turmoil creates change, the sudden turmoil has a huge potential for mistakes. The slip-ups are very likely to leave a degree of paper trail, which in some lucky cases we can access by way of public registries and corporate property documents, etc. But otherwise, they can be potentially discoverable by legal orders a bit further down the line. So this to say that right now is really the time to be monitoring the movements of change. Next, moving on to the bad. This crisis, what it's created is a real huge realm of challenges to governments, amongst lots of other things. We see lots of these governments that are now looking to access cash, to subsidize government schemes, medical equipment, and to offset, of course, their own debts. But it's in particular the sovereigns that have for a long time relied on unhedged oil flows that are going to be the ones that are most affected. And some of these countries, when we look at them, also happen to be the ones with some of the longest and aggressive list of creditors. And 2 examples of this, for example, are Venezuela and Nigeria. The enforcement against these sovereigns from experience is traditionally focused on oil output. So you've got oil in transit, oil in storage, receivables, cash collection, bank accounts, etc. essentially without the cash flows coming in, the opportunities for enforcement are now a lot more limited. And the other impact that this also has is on how some of these assets can be valued as well. But given this liquidity squeeze, it's not just the enforcement that's going to be complicated, it's any kind of settlement talks that are going to be impacted because cash is simply not available right now. We work a lot on some alternative strategies to seek settlements, for example, via diplomatic, PR routes, and other non-legal routes. And I think these are also going to prove quite difficult given some of the wider concerns that governments are experiencing right now. You can think of, for example, the case of some of the Southern European countries, Spain and Italy, that are fighting quite bulky ECT claims and, and fending off a few of these awards. So this isn't to say that all of the sovereign enforcement work should stop, but that there's definitely some preparation to be done for life post the pandemic. Finally, the unpredictable. Quite a long list, so I've tried to kind of cram a few ideas that we could maybe then talk about. There's definitely going to be more fraud, but potentially less money to pursue. So what we saw in 2008 was a financial crisis that fueled an absolute boom of litigation, arbitration, and many other disputes, many of which we're all sort of involved and very familiar with today. This crisis will very likely follow suit, and you're going to have sort of Warren Buffett's swimming naked analogy is going to be having a field day. But while this represents a surge of work for all of us on this panel and a few of you listening, the chances of recovery are probably going to be a little bit meager given the wipeout that the economy is going to take. A second point, which might be touched upon as well by some of the panelists, is a potential greater leniency from judges. In asset recovery, we're always a few steps behind. We're always operating on the basis of information deficiency. And the lockdown has to an extent exacerbated this. That said, there was a decision a couple of weeks ago in New York where Unión Fenosa, which is a Spanish-Italian energy company, they were allowed to seek discovery under a 1782 application from the Depository Trust Company in an enforcement of quite a large award, a $2 billion award against the Republic of Egypt. Now, the DTC is a central entity in the administration of and the flow of bond repayments. Now, the US courts, they've notoriously shied away from 1782s being used in the context of fishing expeditions and the enforcement of awards. So, maybe a question for lawyers, could we expect a degree of leniency in these lockdown times? A third crucial differentiator is the litigation funding market. And, right now what we see is the reexistence of a much more robust litigation funding market. They're pumped with cash and they're raring to go. The issue, of course, for them is going to be selecting which cases to take on, because the crisis will most likely cloud the recoverability prospects, and the funders are going to have to be really shrewd and much better informed about the chances of recovery for their investments. And finally, time. Time is the biggest unpredictable of all. How long is this crisis going to last for? How long till we start seeing some economic recovery? How long until life resumes some normality? And unfortunately, right now it does take longer to investigate. The courts, while they're operating, as Sam mentioned, there are definitely some delays and some hiccups that we're having to experience. And some countries, like Switzerland, for example, have implemented very strict moratoriums on debt enforcement. So normality really feels a long way away. So to sum up, now is the time to be monitoring potential movements of assets. Now might not be the time to be focusing on the enforcement's recoveries against sovereign states or state-owned companies, especially those that are heavily anchored on oil. And only time will really tell how sort of this good, the bad, and these endless unpredictabilities will play out.
Great. Thanks very much, Joanna. Before we move on to our third speaker, just a reminder, do send in your questions using the Q&A function. We've got some time allocated at the end, so do send some questions over, and say raise your hand as well if you'd like to be put on screen when asking your questions. Now moving on to our third speaker, Benoit Mauron. Benoit is a Swiss lawyer. He was called to the Geneva bar in 2012 and to the New York bar last year in 2019. He works in Geneva as counsel with Swiss law firm Lallive, His practice covers cross-border commercial and fraud litigation, as well as representation in criminal proceedings, with a specific focus on recovery. Benoit will be speaking today about the need for increased vigilance of shareholders and creditors in order to limit the risks of corporate frauds in the COVID context. Benoit, over to you.
Thanks, John. Hello, everyone. As Joanna and John, I'd like to thank thought leaders for having me on the founding committee of this exciting new project. My soft skill, I would say, just like John's, I assume, would be beard trimming or grooming. I know there's still room for improvement on that, but I'm sure John can give me a few advice on how to perfect my skills. As said in the introduction, I am a Swiss lawyer working in Switzerland and only Switzerland. And I thought it would be opportune for me to speak to you about how the current regulation and obligations incumbent on directors of companies to notify courts in case of over indebtedness work out, and how they are currently stayed or alleviated, and the risk that they would cause to potentially cause to creditors and or shareholders. Although the lockdown is conducive to introspection and probably meditation as well, creditors should not stay idle in these times. This recommendation is not so much addressed to creditors of public companies or companies whose shares are publicly traded, but more to those of private companies. Indeed, as financial pressure on all economic players has increased because of the economic slowdown, and directors of Swiss companies may be tempted to either favor certain creditors to the detriment of others, despite looming insolvency, or to even appropriate corporate assets to sustain their own lifestyle, which itself has not slowed down. First thing first, the ordinary regime under Swiss law, Article 725 of the Swiss Code of Obligation makes it an obligation on the board of directors to notify the court without delay when substantiated grounds suggest that the company is over-indebted. Of course, directors may simultaneously file a restructuring plan, which, if credible, may suffice to postpone insolvency and let them operate under the supervision of the court or a court-appointed receiver. As in England, and as Sam Uriak will speak to in more detail in a few minutes, a violation of this obligation may, of course, lead to the director's personal liability for damages caused to the company and indirectly its creditors if insolvency ensues. Now, further to the coronavirus outbreak, the Swiss government has passed a few executive orders to alleviate these obligations on directors of Swiss companies. The first one is a relief for directors from their obligation to notify the court of over-indebtedness, provided that first, the company's finances were healthy as at 31st of December 2019, which would implicitly mean that their current financial distress was caused by COVID. And second condition, that reasonable prospects exist to achieve financial rehabilitation by the 31st of December 2020. This is a self-assessment to be made by the directors and to be recorded in writing. By way of a second executive order, the Swiss government has set up a scheme allowing Swiss banks to dispense bridge loans to companies on preferential terms and after an expedited due diligence process. Those loans will be secured by the Swiss government up to 10% of the company's yearly turnover. And these loans that are easily accessible to now Swiss companies shall not form part of their liabilities for the purpose of assessing whether the company is over-indebted or not. So they would be treated as not as liabilities, but not as assets either, but they would be neutral in these examinations. Of course, recipients of these loans are prohibited from using the same to pay out dividends, to extend loan to shareholders, or to repay loans to other entities of the group. But these two deviations from the original regime were of course necessary to allow companies to resist the current economic crisis, but they may also give room for directors to defraud the company and their creditors. This might apply to ill-intentioned directors. They may take advantage of the exceptional temporary relief to perpetrate fraud, but more problematic also to well-intentioned directors who may misjudge the situation and make ill-advised business decisions that would turn out to be detrimental to the creditors. The issue being now that because of the relief from the duty to notify the court, ill-advised the situation will not need to be immediately reported to the court, and the court will not be involved to stop further losses. Furthermore, the risks are increased by the general chaos in the COVID context and the ensuing slowdown of the judicial system. In Switzerland, the courts have almost shut down altogether for some time, only operating on a very limited budget and basis for urgent hearings. This is why my plaidoyer would be for creditors to be proactive and not wait for possible insolvency and the embedded tools such as reversing antecedent transactions and the like, which are provided for by the Swiss insolvency law regime, but to be proactive. They may do so either on the basis of contractual provisions, which could, if existing, allow them to obtain information from the board of directors about the financials of the company, about the current status, which could allow them to also obtain certain documents. If in the absence of contractual provisions, they could potentially resort to the courts to access certain limited corporate information, such as the annual reports and audit reports. And in case the directors are not forthcoming with their requests, they could contemplate seeking an ex parte interim order attaching the company's assets to secure their debts, arguing that the company is likely to now reach insolvency and to try to avoid paying its debt to the creditor. Very shortly, as time is running up, the same applies to shareholders. They are next in line after the creditors, obviously, but still retain a certain interest in the good standing of the company. They should, if at all possible, be very cautious about the operations of their company. They should ask information and documents from the board of directors, which they are entitled to. They must exercise these rights at shareholders' meetings, which should be convened as regularly and as required by the circumstances. I might add here that shareholders representing 10% of the capital may convene a shareholders' hearing, if necessary, by way of court proceedings. If this is not forthcoming, they may try to have a court-appointed external auditor appointed to examine and review the company's books. And if this still does not succeed, this will set ground for a subsequent personal liability claim for damages against the directors who were not forthcoming. So what I wanted to say is that in these circumstances, do not stay idle, be proactive, and try to get as much information as possible to avoid sustaining losses. Thank you very much.
Great, thanks very much, Benoit. And I should add that probably the new skill that I've learned recently is to pay my fellow panelists for compliments at the beginning of their speaking slots. Moving on to the next speaker, Emma Rowan from Peters & Peters. Emma is of counsel and has extensive expertise in civil fraud litigation, in particular in obtaining and defending worldwide freezing injunctions. Amongst her work highlights is her work on behalf of the Department of Health in litigating private damages actions, where there are allegations of abuse of dominance position and entry into arrangements. Emma will be posing the question today as to whether now is the time for genuine cooperation in relation to overly aggressive inter-parties correspondence.
Thanks, John. I'll start off with my skill. I think I have become incredibly good at sourcing the delivery of donuts from around London, making sure that my sugar high is maintained throughout the lockdown. If anyone wants some tips, then please let me know. I thought I would just talk about how litigation generally proceeds in England. Certainly it's my perspective, feel free to add any comments you might have. I would say that increasingly parties' legal representatives are being expected to cooperate, and aggressive approaches to litigation are being actively discouraged by the judiciary. However, in my experience, parties to hotly contested litigation continue to use every means at their disposal to inconvenience their opposite numbers. Often the existence of a duty to cooperate is just one more mechanism by which a party can seek to gain an advantage. A good example of this is disclosure. The most revolutionary change to English practice and procedure of late, at least from my perspective, has been the disclosure pilot in the business and property courts. For those who aren't aware of it, or perhaps are avoiding it entirely by starting claims in other courts, it requires the vast majority of disclosure to be front-loaded and for the scope of each party's searches to be defined by a list of issues. The practice direction places a specific duty on representatives to liaise and cooperate with each other, to the extent that if they don't, sanctions may be imposed. Notwithstanding this and the high level of cooperation expected, in February, the Chancellor noted that some parties to litigation in the business and property courts had sought to use the pilot as a stick with which to beat their opponents, and those were his words, not mine. The Chancellor described such conduct as entirely unacceptable and worthy of adverse cost orders, although it remains to be seen whether sanctions will ever be imposed in respect of deliberate attempts to complicate the disclosure process or frustrate agreement on the scope of disclosure. Although they may never be ordered, you can bet that somebody is going to ask for sanctions to be applied in respect of breaches of the pilot. As certainly since Mitchell, parties have exhibited a degree of opportunism when faced with a failure by their opposite number to adhere to a procedural obligation. In Mitchell, which you will recall arose from the Plebgate scandal, the claimant's budget was confined to court fees because it was filed late. From the date that the decision in Mitchell was upheld, a steady stream of matters came to court whereby one party, either legitimately or illegitimately, sought to exploit another's failures. This culminated in Denton, where the Court of Appeal criticised the satellite litigation, as well as the uncooperative attitude that Mitchell has fostered, urging parties not to act unreasonably in opposing applications for relief. Notwithstanding this, at least from my perspective, not a month goes by without Mitchell or Denton or both being mentioned in the context of an application for relief from sanctions, where one party, which is opposing the application, appears to have suffered limited prejudice as a result of the relevant default they're complaining about. I'm not sure about all of you, but I don't think the pandemic has actually resulted in a change of attitude amongst litigators. And I've got to say at the start, I thought that we would all be a bit more friendly to each other and a bit more cooperative. As with the rule changes and developments in the case law, the new normal we all face as a result of the lockdown may just be providing parties with the opportunity to seek to avoid compliance with deadlines or means by which to exploit the opposition's temporary vulnerabilities, as Sam outlined earlier. I mean, Sam talked about some of the case law, and I certainly won't go over it, but I think it's worth noting that in one of the cases you mentioned, Re 1 Blackfriars, it was, in fact, one party considered that the other's application to adjourn the trial was in fact born out of its reluctance to continue with proceedings. And they describe this as more tactical manoeuvring rather than a complaint about genuine problems. In another one of the cases, which I don't think Sam covered, and that's Heineken, a claimant refused the defendant's request to vary the timetable to trial, notwithstanding the practical problems faced by the defendant, including the fact that one of its solicitors, I'm paraphrasing and I'm quoting the judgment, one of the solicitors had regrettably come down with a virus and couldn't do any work on the expert report. In that case, the court actually did order a short extension of the applicable deadline. Of course, we're not going to hear about all of those cases where the parties have worked together to achieve an acceptable compromise as a result of the COVID difficulties, because those aren't going to result in publicly available judgments. But I think at least, from what I've heard, at least anecdotally, it appears that some parties are being afforded very little leeway despite genuine issues. And perhaps others are over-exaggerating problems they may be facing to gain valuable additional time. I'm sure John will cover this later, but I'd be interested to hear others' experiences of litigation and whether they have perhaps experienced nicer opposition than I have.
Great, thanks very much, Emma. Our fifth speaker today is Sam Oriak from Grant Thornton. Sam works in Grant Thornton's Insolvency and Asset Recovery Department, specialising in complex, contentious and cross-border insolvency. He has over 10 years' experience in this area, now based in London, with significant time spent in working offshore in Grant Thornton's office in the Cayman Islands and the British Virgin Islands. Sam will be talking today about the suspension of wrongful trading. Sam.
Thank you, John, and thank you, Emma. I can't believe litigators aren't being nice to each other. The things I've learned is basically how much can be achieved from a simple laptop on a desk and a phone. It's just quite remarkable. And my new skill, I'll show you. Yes, I've been that bored. So good afternoon, everyone, and thank you for attending our first FIRE community event. I'm going to do a quick presentation covering the recent announcement on the suspension of wrongful trading. And we'll look at what wrongful trading is and further details of the announcement and what the implications are for us all. So what is wrongful trading? You will be aware that liquidators may pursue a director through the courts for wrongful trading. The definition of wrongful trading is set out in section 214 of the Insolvency Act and states, if it appears that before the winding up of a company, the director knew or ought to have concluded that there was no reasonable prospect that the company would avoid going into insolvent liquidation, the director is liable to make such contribution to the company's assets as the court thinks proper, unless the court is satisfied that the director took every step with a view to minimising the potential loss to the company's creditors. Wrongful trading can therefore result in a personal liability. So what is the announcement? Well, on Saturday the 28th of March, Business Minister Alok Sharma announced a proposal for the urgent reforms to UK insolvency law designed to protect companies and their directors during the COVID-19 outbreak. As part of a package of measures, it was announced that there would be a temporary suspension of Section 214. There's little technical detail on the new insolvency measure and no draft legislation has been seen as yet. But the Business Minister did say that the government hopes these measures will give directors greater confidence to use their best endeavours to continue to trade during the crisis without the threat of personal liability should the company fall ultimately into insolvency. So what is the government trying to achieve here? I think it's two things. Firstly, it is a confidence piece. It's giving a message of confidence to the business industry. The government will stand behind you and they are on your side. Directors should pause before they make any critical decisions on the life of their business. And government is hoping for a V-shaped recession, a quick bounce back. Secondly, I think is an access to funding. In normal times, increasing liabilities, drawing on more finance whilst your company is facing a terminal situation would be a key part of a wrongful trading claim. The government has tried to allay these fears. It's given the directors the authority to draw down on the appropriate funding, keep their companies on life support whilst there is a temporary pause in normal trading. And what are the implications now? The suspending of wrongful trading presumably means that additional debts incurred during the suspension period would not form part of any claim. The questions are then, if the director was trading wrongfully prior to the 1st of March, then continues to trade after the 1st of June, how would you quantify the loss? Do you pause it at the 29th of February and then restart the clock at the 2nd of June? Or say they started trading wrongfully during the suspension period and continued afterwards. Do you start from the 2nd of June, or do we extend further into the future, giving them credit for this uncertain time? The practical impact of this is that in future cases, we'll have to bear in mind the wrongful trading provision was suspended for a period. If we look a few years down the line, when hopefully COVID-19 is a long distant memory, it would be pretty brave for a director to rely solely on this suspension as a defence, considering it isn't in law yet. So in conclusion, has anything really changed? Well, orders for wrongful trading are very rare anyway. The difficulty is in identifying that moment when an event fundamentally overtook the right of a director to be optimistic. Quoting a judgment on one of the cases, if you're not by nature optimistic, you will never be a director of anything. Wrongful trading operates against the purely fanciful, not against the optimistic. The suspension of wrongful trading rules should be treated with caution by directors. It's not a relaxation of directors' fiduciary and statutory duties. There's still the threat of director disqualification, and directors can still be sued for various other misfeasance and fraudulent trading acts. I'll leave you with the views of our internal chief technical advisor. He's a bit of an oracle in these insolvency matters, and he puts it this way: I like to think of the suspension of wrongful trading as a signal from the government, foremost to directors, but also to the courts, insolvency practitioners, or aggressive creditors, that in the current situation, directors can properly carry hope into the unknown. And that's me finished. Back to you, John. Thank you.
That's great, Sam. Thanks very much. And your Rubik's Cube skill is something I definitely want to learn. And it reminds me, if any of the audience want to set some more puzzles for our esteemed group of panelists, do send some questions in. We've had a couple so far. We've got two speakers to go, and then we can launch the Q&A session. So on to our penultimate speaker. Our penultimate speaker is Natalie from Skrine in Malaysia. Natalie is a commercial litigator who focuses on company law litigation, restructuring and insolvency, and fraud and asset tracing. Natalie will be speaking today about restructuring options and risks for companies in a time of corona.
And thanks, John. Very glad to be part of this committee as well. So my new skill is rock climbing the underside of my staircase because I can't go to the climbing gym anymore. So anyway, today I'm just going to touch on two possible rescue mechanisms very quickly, which may be considered by companies at this time. So number one is a scheme of arrangement, and number two is judicial management. So these are for companies which are currently almost insolvent or on the verge of insolvency. And I'm getting a lot more inquiries about these two processes in my current practice. So firstly, the scheme of arrangement, it's about the same in Malaysia, Singapore, and in the UK as well. It's a process where a company tries to strike a deal with its creditors to alleviate some debt, and this deal is then approved by the court if the company can get the requisite 75% majority approval in value of the creditors to the scheme. The scheme then becomes binding on all creditors, including any minority creditors who voted against the scheme. So briefly, it's a three-stage process. Firstly, you apply to the court to get approval to convene the meeting of creditors. Secondly, you then hold the creditors meetings where you have to divide the creditors into classes where necessary. So for example, unsecured creditors should not be in the same class as secured creditors usually. Once you get the approval of the creditors, you then go back to the court to get a court sanction of your scheme. And then that's when the scheme becomes binding on all creditors. So why do people opt for schemes of arrangement? The most important reason is because where one or more minority shareholders or creditors seek to block the restructuring, if you get a scheme, you can bind those minority creditors to the scheme. So in that way, you will not get one or two creditors blocking your possible restructuring and rescue of the company. Secondly, it also allows the company to present more creative options to the creditors for the creditors' approval. So a lot of the times you will have what is called a white knight to come in to rescue the company, to pump in some capital into the scheme. And this can also all be worked into the scheme of arrangement and presented to the shareholders. So some of these options you will not get in a normal formal insolvency proceeding. I'll go a little bit into moratoriums. I know that in the UK, there's no ability to apply for a moratorium for a scheme of arrangement. You have to rely on lockup agreements where the creditors will have to then all agree not to bring proceedings against the company. For Malaysia and Singapore, there is the ability to apply for a moratorium against legal proceedings if you manage to satisfy certain procedures and requirements. So now just going into judicial management, which is the second rescue option I wanted to talk about, similar to administration in the UK, but called judicial management in Malaysia and Singapore. So this is where a company is placed under the control of an insolvency practitioner known as a judicial manager or administrator. The biggest advantage of this option is that an automatic moratorium will apply upon application. So once you apply to the court, immediately legal proceedings will be restrained. And this moratorium will apply throughout the time of the judicial management order. And again here, the judicial manager will try to put forward a restructuring proposal to the creditors for their approval. This will also have to then be approved by the creditors, and then it will also become binding on all the creditors. Now, the judicial manager will take over all functions of directors within the company. And people opt for judicial management because of course, the automatic moratorium. That's the biggest reason why you would opt for judicial management. People also opt for it because there is the assistance of an insolvency practitioner who is a third party, independent to the company. And this helps where, for example, you may have some mismanagement issues or some poor management issues by the directors of the company. And in our time, sorry, just conscious of the time. In this time of pandemic, companies may struggle to fulfill some of the criteria needed to trigger these rescue options. And I know that legislation is being introduced in certain countries. For example, Singapore, you have your COVID-19 Act, which gives legal reprieve for 6 months, where certain companies can't fulfill certain contractual obligations. Malaysia has also introduced a higher monetary threshold for winding up. And I think in the UK, there are proposed moratoriums of up to 90 days on insolvency proceedings for companies. But I think that right now, more detailed legislation is needed specifically for rescue options so that companies can take advantage of these options during this time. So that's it from me. Back to you, John.
Great, thanks, Natalie. Last but not least, we've got Keith Han, who's at Clifford Chance in Singapore, and he practices litigation and international arbitration, focusing on complex commercial disputes, fraud and asset rating, and restructuring and insolvency. Keith's going to be speaking today about the use of mediation to mitigate risks during a time of crisis. Keith.
Thank you very much, John. Like my colleagues, I'm delighted to be on the founding committee of Firestarters, and I look forward to getting to know and working with all of you. In terms of the new skill that I picked up during the crisis, it would be meditation. I've been wanting to pick it up before the crisis started, but always found it a challenge to get into my routine before I start work. Now that I don't actually have to travel to go to work, I found it a lot easier to get a routine started, and it's been a great way to start the day. In terms of what I'll be speaking about today, it's not often that you hear someone talk about mediation in the context of a seminar on fraud, insolvency restructuring, and asset tracing. But I thought I'll switch gears a little and share my thoughts on why it would be actually worthwhile to consider the use of mediation for some of the disputes that arise during the COVID-19 period. I can think of 5 reasons why one might find it worthwhile to consider mediation. The first reason is that the commencement of formal legal proceedings may not actually be possible. Many countries have amended their laws to provide temporary relief for companies and individuals for their ability to perform certain contracts For instance, you have moratoriums against the commencement of legal proceedings, you have moratoriums against the enforcement of certain security rights, etc. And as you have heard from some of the other speakers, the bankruptcy and insolvency thresholds have been adjusted as well. So what this in effect means is that for the next few months, it may actually be quite difficult to actually commence formal legal proceedings against counterparties who are unable to perform due to the COVID-19 measures. But the situation that you have is that the substantive obligations will remain despite the inability to commence legal proceedings, just that the obligations will be deferred until the end of the standstill period. So you may have a situation that when the standstill period ends, there'll be a flood and a multitude of proceedings that are being filed in court and in arbitration as well. And that's, I think, what led to Lord Neuberger and Lord Phillips in a few days ago coming up to make the plea to commercial parties to consider a consensual solution to some of the disputes. And mediation obviously offers one avenue of doing so. The second reason is that it's fair to say that the move to the virtual world has placed a fair bit of stress on many court systems. I think while many courts continue to hear cases, the pace at which cases are being progressed through the court system are slowing. In Singapore, for example, we have a quasi-lockdown situation right now. The government calls it a circuit breaker, which will last until the 1st of June this year. So in Singapore, the Singapore courts are only hearing what they deem to be urgent and essential cases. So for the cases that are not deemed urgent and essential, they have been adjourned to be heard after 1st of June. So therefore, this means that there'll be delay in terms of ability to obtain final relief. In terms of your ability to enforce, that may be affected as well, because even assuming you're able to get final relief and obtain, say, a writ of seizure and sale, are you able to execute that writ in this climate? Likewise, if you have managed to obtain an order for arrest of a vessel, there may be practical difficulties in your ability to do so. From a litigant's perspective, I think as others have mentioned, there may be issues in terms of evidence collection, for example, if physical evidence is involved and is not easily accessible. The third reason for considering mediation is that there is considerable uncertainty, I would say, in terms of how substantive rights are affected by the crisis. So given the unprecedented nature of the COVID-19 crisis, it remains to be seen how tribunals and courts will find rights are being determined. So given the uncertainty, mediation may be an option that some parties would like to consider. The fourth reason is obviously mediation is a flexible process and it allows for creative solutions which one may not be able to obtain through a court or arbitration process. In a situation where companies are seeking to conserve cash flow and resources and maintaining good business relationships with their suppliers, etc., mediation may offer solutions. For example, if there's a need for an interim solution or an interim position that needs to be agreed, mediation offers an avenue for parties to thrash out those issues and come to a compromise. In a multi-party scenario where it may be difficult to consolidate proceedings, etc., including insolvency proceedings, mediation offers a chance to deal with all stakeholders' concerns. I think the final reason why I think it's worthwhile to consider mediation is that it's affordable and it's time efficient. Most of the mediations that I've been involved in are concluded within the span of 1 or 2 days. So again, it's worth, I think, in this climate, taking a shot at trying to resolve issues that crop up during mediation. And that's all I have. Back to you, John.
Thanks, Keith. Thanks to all of our panelists. It's now time for the Q&A session. As mentioned earlier, we've had a couple of questions fired in so far. Feel free to send in any more questions you might have. But I'll kick off Q&A session with a question from Luke Harrison from Keaton Harrison. Luke's question is, do you think that the introduction of remote hearings and e-bundling increase the efficiency and reduce the costs of freezing order, search order, and other interim relief applications? I think Sam Goodman has kindly volunteered to answer this one.
It's a good question. I think unfortunately the answer is no, not really. The prep time will be the same. It will take just as long to prepare the evidence. What it will save in a very heavy application is printing 40 volumes of a hearing bundle, but that's probably not in context the biggest saving. The hearings themselves will either take the same amount of time or they'll take slightly longer. And they'll take slightly longer either because the technology means that things go a bit more slowly, or because there comes a point when you're talking to the judge about the injunction where both the advocates and the court have to consider what adjustments have to be made given coronavirus. So how are you going to serve things and how are you going to swear affidavits and do searches and questions like that. So if anything, I think the hearings themselves will take longer. Although it's not a cost saving though, my recent experience is that electronic bundles are far, far superior, because instead of having trainees from each law firm scurrying to court in the run up to a hearing, constantly adding various bits to the judge's hearing bundle, you can just do it all seamlessly and instantly. And that's not a cost saving, but it certainly makes the administration a lot easier. But I think the short answer to the question is unfortunately not really.
That's great. Thanks very much, Sam. See, we've got a question from Louise Traherne. I'm going to try and join Louise in so we can all see her and she can ask a question directly. Just bear with me. Louise, have you managed to join us? Okay, well, let me ask the question. Ah, there's Louise. There we go.
Hi, can you hear me?
Yes, perfectly, Louise. Fire away.
Okay, well, this is a question for Joana. Very interesting talk, and thank you to all of the speakers. They're all very interesting. My question was just a sort of trend watch. Have you seen any change in client law firms being willing to pay for the investigation and asset recovery work before a case is filed? It's often a point of contention, but have you seen that being a problem? And then a suggested solution, and whether you think it would work, is a way of using litigation finance insurance as an asset, and then going to your bank and saying, hi, I've got this litigation insurance, it's an asset, it's got a minimum value, will you extend my credit lines with recourse to that insurance? That would create a new pot of money, potentially to use on the initial investigation.
I mean, I think in quick answer, we haven't necessarily noticed a shift or a change. You know, I mean, there's a degree of reluctance which is still there, I think, on behalf of the funders. From our perspective, since the lockdown started, we've taken on 2 cases for funders. One was funded by the funder, and the other one, the funder was asked the client to essentially invest directly in the due diligence. I do think that right now that the due diligence, and particularly this recoverability, the asset tracing pre-taking on some of the cases is going to become even more important than it was 6 or 7 weeks ago. You know, you're going to have a lot of shifts in the solvability of companies. You're going to have a lot of shifts in the economic patterns around companies and individuals, and you're going to have the movements that we were discussing earlier. And so it's going to be crucial to essentially set out what you're going to be looking for and where you're essentially going to recover your investment. In terms of some of the provisions that might be available, you know, it's very possible. I think, you know, like we're animals that adapt, you know, and we tend to find solutions to the problems we have. So there must be a degree of provisions that will be set out, and everybody's going to have to become much more creative and adaptable as well in using some of these provisions, you know, and the insurance market will, I'm sure, be there to support this.
Thanks very much, Joanna. Got another question from Maurice McSweeney for Keith. Let me just join Maurice in so he can ask his question. Maurice, can you hear us okay?
I can hear you okay. Can you hear me?
Yeah, perfect. Fire away.
Great, fab. Thanks all very much. Really fascinating session. Keith, or indeed anyone, you were talking about potential increase in mediation, and we heard on the radio here, like you said, our judges suggesting the same thing, that parties to disputes may wish to go to settlement through mediation rather than going to litigation or arbitration. I think a historic reluctance about parties going down the mediation route has been a concern over enforcement and whether or not that can be effectively whether or not judgments or awards can be effectively enforced. So, I mean, given the current climate, do you think we might see a bit more traction for the Singapore Mediation Convention and states trying to get a bit more behind it and getting it ratified as quickly as they can in the current circumstances, given that it may be a way to alleviate pressure in the coming months or years on their domestic court systems?
Thank you, Maurice. It's a good question, and I'm certainly hopeful that that would happen. I mean, when the Singapore Convention was signed, I think you have over 50 states who signed on to it. So that's not a small number. I think the problem that you have right now is that while these 50 states have signed on to it, I think only 3 states appears to have enacted the convention into the local laws, Singapore, Kuwait, and Fiji. So I think I'm hopeful that over the next few months, despite the obviously local issues relating to COVID-19 that's occupying legislatures around the world, that they will see the benefit in enacting the Singapore Mediation Convention into their local laws, and then we can reap the benefits that the convention provides, which is namely the ability to enforce across borders mediated settlement agreements. So I'm hopeful. I don't think we're going to see countries rushing to enact the convention into local legislation, but I think, you know, in the next few months to a year, I think that we can anticipate to see more countries signing up.
Great. Thanks very much, Keith. I think we've probably got time for a couple more questions. I've got one that I'm going to fire to the panel as a whole and see who's happy to answer. I think in the current climate, obviously, one of the issues that we all face is getting hold of information and documents through various means, whether that be insolvency practitioners using their powers to interview witnesses, to collecting documents, from Joanna's perspective in terms of surveillance, human intelligence, collecting documents from other sources, and equally in other types, shapes and forms like search orders. How are those going to be executed in the current climate when people are social distancing or self-isolating? So can I throw open the question to the panel, what their thoughts are in terms of getting information and documents? Perhaps start with Sam Oriak from the insolvency perspective.
Yeah, thanks, John. I think if you'd have asked me 5 years ago, I think we'd have been in a bit of trouble, to be honest. The increase in capacity, and as I said earlier, what you can do from your laptop is just amazing at the moment. Yeah, it's not really slowed us down at all. Yeah, we can get information, we can get correspondence with banks, get the bank statements, solicitors' files. We've recently just picked up some companies' hard copy books and records from a storage facility. The storage facility is still open. We managed to arrange an agent to go and collect that kind of stuff. So it's pretty good. We've even had one of our team had an interview with a bankrupt last week. They went to and they did it via Zoom or via Teams, I think it was. And they were the bankrupt was in Israel. Their solicitor was in Europe somewhere. So it's it can be done, and it's just thinking outside of the box and using the technology that's available to you.
Great, thanks, Sam. Joanna, do you want to step in from your point of view?
Just a quick point on, indeed the digital world has been magical for us, and it does allow us to access quite a bit of information from behind our laptops. But whereas some countries do have systems that are fully digitized, there are others that don't. There's a lot of countries, if you think of a lot of African countries, South American, where you still have to go, and the Far East as well, where you still have to go and manually retrieve quite a lot of records. And a lot of these registries are either closed or they're operating at, quite skeletal staff. So it's, one can get to them, but it definitely takes a little bit more time. And even simple things like, today we received a PN1 from company's house, which usually takes 2-3 days to get, and took us over 3 weeks. I think on the human source, the source development work, that has definitely been sort of made a little bit more complicated because, in part, it's a type of work where one is creating relationships with people, where one is, studying their body language, where you're spending time, where you're essentially developing a relationship to essentially get someone to help you out on a situation. And that's definitely harder. Just before the lockdown, I had a trip booked to go and spend a week. I had 5 interviews booked, and we made those interviews into telephone calls and video calls. And, what was meant to be a nice leisurely lunch sort of became a bit of an awkward behind a screen, with one of my kids running in the background. So it's just not at all the same thing. That said, we've had also, I think similar to Sam, we're starting an internal investigation now as well, and we're going to have to conduct a few of the interviews via Zoom and Skype. And the flip side is this is probably going to become a new norm, and we're going to have to adapt as well to a situation where people are going to feel a bit more comfortable in meeting via Zoom and via, virtually, as opposed to even face-to-face. So that can be a good thing because, it's quite tiring to be flying all the way around the world. And so it can be a good thing in the future, but definitely we're sort of having to learn new skills.
Excellent. And from the search order perspective, Natalie, what are your thoughts on that? Need to unmute you.
Oh, sorry. Sorry about that. Yep. So in the time of social distancing and self-isolation, I think the court will have to definitely have all these measures very, very clearly in the order itself. Everything will have to be spelled out. I think supervising solicitors will have to play quite a large role in that area as well, in order to help regulate or sort of self-regulate. Actually, I think there'll be a lot of self-regulation in that area because the court can say anything they want, but whether it actually happens, I think the supervising solicitor will have to play a larger role there. And perhaps when someone has been in contact or the target has been in contact with an infected person, maybe, the search would probably have to be delayed. So I think I foresee that sort of delay there.
Thanks, Natalie. And Sam, do you have anything to add from the Sam Goodman, that is, from the UK perspective?
Yeah, if I envisage trying to take a judge through a search order and explaining how it's actually going to work, I don't think it's unrealistic to think that we should be thinking about things like, when available, tests for the search party, potentially hazmat suits for the search party. If it's an office premises, then requiring the office to be evacuated, even potentially paying for a deep clean after the search. So I think it's really up to us to have a think when we're asking for these orders about how we can give judges confidence that they can be executed in a safe way. And it may be that we have to confine ourselves to narrow orders like doorstep imaging orders rather than actually going into somebody's property, but that remains to be seen.
Well, I suppose there's also, when you're dealing with especially residential search orders, like the current climate, everyone's relying upon laptops, personal devices, etc. That's their way of communicating with the world. So that's something that also consideration will be need to be given to that, and help people can be given access to the world whilst their devices are being imaged and the like. That's another thing I suppose we all need to think about when the time arises. I think probably one last question. Emma raised during her talk the question of, are we all being nice to one another now? I can certainly say from my perspective, things really haven't changed in the cases I've been doing. Everyone is as friendly as ever. don't know if anyone else in the panel has got any similar or different experiences to that.
If by being nice is not responding to anything and therefore not being outright disparaging, yes, they've been nice. But apart from that, people have just not responded to anything, and we've experienced slowdown rather than cooperation, unfortunately.
I think people have been angrier, and it may be because they're spending so much time at home with their kids and families. But certainly, there's been no difference as far as I can tell.
Great. Well, thanks everyone. I think we've probably run out of time, unfortunately. So thanks everyone for attending today. I hope you found that as stimulating, as an enjoyable session as I have. I'm sure that the rest of the panelists have. Thanks very much to our 7 speakers today for their very interesting sessions. If you do have any further questions, don't hesitate to get in contact with any of them or me indeed. I think the next event scheduled in the FIRE community is on the 19th of May. We've got the former UBS rogue trader Kwaku Adeboli is going to be speaking at that event. In the meantime, as I say, thanks very much to today's panel, for everyone for joining. And thanks to Paul, Danushka and Chris behind the scenes who made everything run so smoothly. So I hope everyone keeps safe and well, and we look forward to seeing you at the next event.
Thanks, John.
Thank you very much.
Bye-bye.
Thank you, John. Bye.